Fantastic. So, good afternoon. I'm delighted to see you all. My name is David Hudson, and I am the owner and managing director of the HR department in Clapham and Islington. And I have approached this webinar with some trepidation because everybody's talking about what the potential legislation will be. It's my aim to talk you through what we already know. And I'm happy to take questions at the end so that, we can maybe try and flesh through some of those things, but to say you won't be surprised to know I don't have all of the answers because I think the government itself is still trying to work those out. So I'll do my very best to respond to questions. If you do have questions, please do feel free to use the chat function at the top of the or the bottom of your screen, and that I am going to leave time at the end to answer any questions you might have. So today I'm going to talk to you a little bit about what has led up to the employment law changes, the Employment Rights Bill, which is being introduced, and that's really where the main changes are likely to sit, the impact on SMEs, what you can do to mitigate those issues, and as I said, hopefully try to answer your questions. As you may know, if you've attended some of our webinars previously, I like them to be very interactive. They're very informal. So as I said, please please share any questions that you have or any comments that you want to make. And just to repeat that we will be circulating a recording of this and also the slides. I'll talk a bit more about that at the end. What I am interested to hear, given that it's obviously front of mind for you, is what worries you most about the potential new employment law legislation? So be interested to get a feel from you real time. And if you could take to the chat, and be great to hear just a few comments around what you might be worrying about from what you've seen that's coming up. Just helps me maybe to tailor also some of the content. So feel free to add any comments that you want to make that you might be particularly worrying about at this moment in time. Always silence when you ask people to make comment, and people are always wary. Okay, well, flexibility. Thank you, Valentina. 0 hours contracts being outlawed. Yes, Olivia. Absolutely. One I'm certainly worrying about too. So, okay, feel free, as I say, to use the chat function as we go, and I'll try to address where I can some of the questions that you might have. So, where to start really, and that's at the state opening of Parliament last week. The King announced that that the government will be legislating a new deal for working people. And as the manifesto said, to ban exploitative practices and enhance employment rights through a new employment rights bill. And that's been, if you like, the centre point of the Labour manifesto. The King also talked about the significant changes to living wage and a number of other things that I'm going to walk you through. But essentially, I don't think it's an understatement to say that we do see this to be probably one of the most seismic changes in employment law for some time. So there's going to be a lot for us to deal with in the coming months, I think. What the government have promised to do is to work in partnership with both businesses and working people to drive the changes. But some of the rationale, when you look at what sat behind the King's speech last week, was really about getting people back into employment. And they're still interestingly talking about the after effects of COVID. So there are apparently 2.8 million people still currently economically inactive due to long-term sickness. So there's a big drive to take people back into work. As I mentioned, really with this and any new legislative change, the devil will be in the detail that as yet we are not privy to. But Labour does pledge to make sure it works in conjunction with the unions, with the with businesses, leaders like yourselves, to get things to the right place. So there's been a real emphasis around these changes being more coming from more of a collaborative approach. So the big piece that was heralded last week was the employment rights bill, and I'm going to talk a little bit about what that means, what was included, and how you need to start to be thinking about it. So the employment rights bill is what the government has basically set out to be its first 100 days in office. And the Prime Minister has been quick to say that he's looking to make fairly rapid changes. If you're watching the news, that's already happening in other various areas. What we anticipate at the moment is that the bill will be brought before Parliament just before October. The point to bear in mind is, without wanting anyone to panic, that I don't think that we will expect to see immediate change in October, because once the bill is discussed, it has to receive royal assent, and then the guidelines and all the other things have to be issued so that we're ready to go. So maybe slightly optimistically, I suggest we won't be looking to see big changes before October, but please do not quote me on that. It is all light in detail, and once the legislation has been drafted, I will share that with you as it goes. What sits behind it? Again, something to think about as employers. There is a view that the existing employment laws are outdated and that they're not reflecting current working practices, or actually current cultural practices. So this is maybe, if you're wondering why are these things being picked at, that's why ultimately the government believe that it's time to update what has been referred to as quite draconian legislation. So what will be included? So what we know at the moment is that there are various kind of key policies that they're going to be looking at. So banning exploitative 0-hour contracts, which I'm going to talk about next. Day one rights for workers, strengthening sick pay, looking to make flexible working a default rather than a request process, the establishment of a new single enforcement body. Unsurprisingly, given it is the Labour Party, major updates on the trade union legislation and processes, more protection for mothers returning to work, and to create a genuine living wage. So quite a lot there. For the first 100 days. I think the impact of that, if it's going to go the way that we're being told, is going to be, as I said, fairly seismic. So let's turn then, first of all, to the piece that, as you said in your comments, is probably been fairly widely publicised, and that's been the banning of 0-hour contracts. Now, what's interesting is that the King himself, in the speech, which you may or may not know is written by the government for him to deliver, referred to exploitative 0-hour contracts. And in reading some of the background to how these things have been arrived at, there's a view by the government that these are exploitative, that they are not providing security for people, and that there should be more predictability and security for workers. So that's where this is coming from. Interesting that the use exploitative has been widely used, whereas, as many of you may know, many organizations rely on the use of more flexible contracts, 0-hour contracts being part of that. The government also, in justifying, if you like, why it's moving to this, is that it says that in the last decade, 0-hour contracts have risen by about a million people. So there's this kind of view, really, that the exploitative part of it is that employers are using it to their own greater gain, rather than it being in partnership with people. You may have a different view on that, and I hope you do operate differently in your own businesses. What this does mean is that ultimately, with that status being taken away, we'll have to think more creatively about how we employ people for shorter periods of time. Again, what that looks like, I think, remains to be seen. We would hope that some of the governing bodies, such as ACAS, will help shape some of our thinking around that. But it may be that you're looking potentially to move more into fixed term working or seasonal contracts. Unfortunately, the drawback of that is going to be that we may be faced with higher admin costs, and it'd be a more time, more time expense. So I think the thing with all of the legislation is our advice is to continue as you are, but just be mindful that with something as big as this, you don't want to go into a situation where you're overly committing to loads and loads of 0-hour contracts that you may potentially need to wind back on. So just keep your eyes on how what your staffing model looks like. The next one, again, that's received, I think, quite a lot of social media attention is the additional day one rights for all workers. So parental leave, sick pay, and protection from unfair dismissal will all be available from day one. And by day one, what we obviously mean by that is that the minute an individual joins the organization, they will be protected. And it's not that people aren't protected. So you will be aware that it's a day one right to raise an employment tribunal claim if, for example, there is evidence of discrimination. The unfair dismissal employment tribunal claim at the moment has a 2-year qualifying service requirement. And so what this is about is, I guess, and again, the devil's in the detail here, but what we believe is that we'll be looking to probationary periods as the only sure way of avoiding a tribunal claim, after which, it may well be then that right kicks in, but we haven't had, as I said, the narrative for that as yet. So the unfair dismissal claim piece is after 2 years. You will still have to follow the ACAS code of disciplinary and grievance processes, but you will ultimately need to review your policies and contracts to reflect what the new legislation will be. Again, I wanted to share with you some of the narrative I'm sharing with you is from the Prime Minister's office, who wrote a paper behind the King's speech. And what they talked about here was really encouraging more workers to, interestingly, and I will tell you, it says switch jobs, which is associated with higher wages and productivity growth. So it seems in an indirect way, they see this as a way that people will move around. Let's wait and see. The reality is that at the moment, the tribunal service is struggling under the weight of claims that it is increasingly receiving. And if you take a claim today, there's every possibility you'll be waiting 18 months for that claim to be heard. So for the tribunal claim to be a day one right is going to have a very serious and potentially quite negative impact on the tribunal service. In terms of parental leave, the current position with parental leave is that parents and carers with children under the age of 18 are able to take up to 18 weeks of leave to care for a child. There is a service requirement attached to that, which is 1 year. So there again, what you may see in reality is that at the start of the employment relationship, there may actually be more leave requests than maybe we will have been used to, and that in itself you will need to be, we will need to be ready to manage. So day one rights is going to, I think, also, if we think more practically about how is this going to impact us, largely speaking, this is going to be the thing I think that we feel the most change and potentially the most, the most pain, if you like. Moving on then to strengthening statutory sick pay. The thinking behind this was that it really disadvantages lower paid workers because the current statutory sick pay rules are that the first 3 days are unpaid. And so by removing the lower earnings limit, ultimately means not only do people then get paid for the first 3 days, which is part of the proposal, but secondly, that the removal of the lower earnings limit it is thought that will allow an additional 2 million people to benefit from statutory sick pay. What we know is at the moment, again, from the narrative we're receiving, that there is about 2.8 million people that are absent due to sickness. And this is, this is looking to provide them with more support. What we see is that potentially what could happen is that there may be slightly higher increases in the level of short-term absence because people will be less concerned about losing pay. And it's always been, as I'm sure you'll agree, a bit of a rub where people have been genuinely unwell, and sometimes where a company can't offer company sick pay, those first 3 days unpaid have been difficult, or people have used their annual leave as an example. So in this area, what we'll need to do is look at your absence management policies, and you will want to be talking to your finance colleagues about what the potential increase of costs in that might be. I worked out very roughly, given that the statutory sick pay amount at the moment is £123 a week, that could potentially see an increase of about £66 for those first 3 days, rather than no pounds, which is what you may be paying at the moment. Okay, so flexible working, an interesting situation. We've seen in the last year that the flexible working legislation has arguably tightened up. Individuals have had the right to make 2 requests for flexible working in 12 months rather than the original 1. There's going to be a view here that flexible working will be a right, so you won't have to apply for it. It will be anticipated within the employment relationship that that is going to be something that has to be automatically considered. Albeit, as with the current flexible working legislation, there are caveats to what may be reasonable or actually inference of unreasonable if you receive these requests. This is all really driving the agenda that sits behind this, is about reflecting the modern workplace. And so it's really trying to, I guess, get closer to actually what we see as modern working practices, albeit we are very aware from the clients that we work with that flexible working in the main is fairly well considered and seen as an advantage, and people tend to work collaboratively with their employees to be flexible. But what it does mean is that the employee will have a greater opportunity to require it, and we would have a higher bar, I think, to get across if we're not able to accommodate it. So there again, certainly I'm suggesting that you should review your flexible working policies, but quite how that's going to be translated in the new legislation remains to be seen. We find this interesting. We do get asked to support with flexible working requests, but actually I don't think they're as common as maybe people actually believe. And actually, to be fair to our clients, we don't always get to formal processes to work with employees to get good outcomes. Often these things happen by mutual consent. So the next big piece is establishing a new single enforcement body, and that's going to be looking to draw together all of the enforcement around the employment legislation, and give that body powers to look at where where legislation's not being properly applied, or where things are not being properly implemented. There's little detail around what that looks like. I was being vague because I don't have that detail, but it might be almost a HMRC-esque type agency that will be able to carry out inspections and make charges. Again, please don't quote me on that. That information has not been confirmed, but it will continue to put pressure on you to make sure that your practices and your policies are in line with current legislation and are being implemented effectively. And broadly speaking, we see amongst our clients that will be the case, but people don't know what they don't know. And this is something to think about here, I think, is often people can be blissfully unaware, and unintentionally so, of what the employment legislation requires What this will do, unfortunately, I think, is shine a bit of a brighter light on those people who won't be able to say, well, I'm sorry, I didn't realize that was the requirement. So yeah, let's watch and wait on that. The new government are committing to work much more closely with the trade unions. They want to update the union legislation. I think from some of the things I've seen this week, for example, there's maybe a bit of a reverse position on the Conservative government's attempts to minimize disruption through striking on public services. This is going to be more about strengthening that opportunity for those things to happen. So I think we're going to be seeing some of the rewinding. And as I said, to be honest, I think it's fair to say we've already started to see some of the undoing of the Conservative policies. What we do know is that Labour are planning to reinstate many of the trade union rights that were restricted. Obviously, as a party, Labour will always want to work very collaboratively with the unions. The sense I get with this is that this will helpfully allow employees to access unions and for unions to be able to support employees without what potentially was quite a high bar previously. So this is really sitting behind this ideology of this new legislation about strengthening employee rights and making sure that they are protected and supported, which can't ever really be a bad thing, to be honest. During the speech, it was announced that the government would look to deliver a genuine living wage that accounts for the cost of living. Who knows what that means? You know, we still don't have detail on that. It's interesting that whilst I think absolutely no one would disagree that being able to pay a wage that means that people can live in an appropriate way without discrimination is absolutely where we should be headed towards. The reality is also that businesses are struggling as it is, and sometimes the wage costs make things slightly prohibitive. So you will want to be looking at your financial situation and really just, I guess, being prepared for what comes with this. Again, I'm sorry to say I can't tell you that, but we do think that it's going to be in the first budget. So more information on that to follow. Interestingly, here also just to shout out that there is a piece of legislation being worked on called the Equality, Race and Disability Bill. And that is going to be quite impactful because that's looking to move more into the equal pay for ethnic minorities and people with disabilities arena, which has certainly been flouted over many years, but this new bill, this race and disability bill, will be making that law. So if you are working in large organizations, and by that I think we see this being probably the 250 plus employers, then that will be something you will want to start thinking about now around how you are, how you are able to pull that information together. Again, an interesting one, this one, an extension, if you like, from what we saw earlier in the year, which was an increased amount of protection for mothers returning from redundancy. So it moved partway out to provide additional protection. This new piece of legislation is really going to go all the way out, essentially to protect new mothers and make it unlawful to dismiss for 6 months after return to work. These all come with conditions, as I'm sure you will be aware. There will be reasons that we can and we cannot dismiss. This will become, I'm sure, an automatically unfair reason, but it's not strictly prohibitive. Not that we will want to be dismissing anybody for no exceptionally good reasons. So please make sure you continue operating as you are. Remember already, returning mothers are protected with the redundancy legislation that changed this year. But you will be wanting to think about, excuse me, who those people might be in your workforce and just satisfying yourself that everything is as it should be, which I'm sure it will be. and that there are no hasty and badly thought out decisions made around mothers that are looking to return to work. Some other changes I wanted to also call out. I didn't want to blow your mind with all of these changes, but some of the sub changes that have not been got a lot of attention is a change in pension legislation. So it will be, this is going to be about strengthening people's ability to keep track of their pension pots and the consolidation process for defined contribution pensions. I've talked about the redundancy protection period for pregnant employees. Some interesting things, thinking more about the clients that we work with. So there's going to be an establishment of a fair pay agreement in adult social care. And that's going to then be if you like, a test case that's going to be looked at to see whether this fair pay concept can be used across other sectors. The Skills England bill is going to be looking to improve the skills development system, which has received, I think it's fair to say, mixed reviews, and look to focus on what are the skills essentially needed in the economy and how, as government, do they deliver and fund that to drive economic growth. And the other really good piece of legislation coming through is the Children Wellbeing Act. So that's really going to be looking at putting children at the centre of education and social care. And that also aligns with some new work that's going to be done around mental health. So I think that legislation is going to be strengthened so that there's additional protection for people that may be dealing with mental health conditions and how they should be treated. So a lot there, it's fair to say. I'm going to pause for a moment just to check in on the questions. Unsurprising, probation, the word probation quickly jumps out. So any change in the process of dismissing an employee who underperforms? It's I would not say with certainty that there's going to be no change. And in fact, I wouldn't suggest it. You know, any dismissal should be very carefully managed and through the right processes. The difference, if you like, here is that if you dismiss someone at the moment with under 2 years service, there can sometimes be a situation where you use a short-term dismissal process because the statutory code is not in place it is in place, excuse me, but you're not going to be tested on it because there's no unfair dismissal tribunal claim can be taken prior to the 2 years service. So I think the point here is, and it's a great question, you do just need to be managing dismissals in the right way, using investigations, being objective, being impartial, making sure there's no discrimination. That will keep you out of tribunal, whether the qualifying period is 1 day or 20 days, 1 day or 20 years. Does the probationary period get extended if a new hire takes parental leave during the probationary period? Great question, Martina. I think the devil's in the detail. There is currently the right to extend the probationary period. Whether that right will remain is to be seen, and whether that right's caveated to, to things like parental leave, I think, again, remains to be seen. How long probation can be, and can training period be excluded? So probations at the moment are typically 3 to 6 months, depending on various factors such as seniority of role, training requirements. I would expect, and I can only speak from a personal perspective, but I expect we're probably only going to see a maximum at best of a 9-month probation periods in the new legislation. Don't quote me on that. I don't have any insider information, but we ourselves would not recommend generally anything past 6, to be frank. Olivia, day one counts as day one of employment. Yes, day one of employment, not after probation ends. So great questions there. Thank you. And do, as I said, please feel free to continue to add them in. So what does that all mean? I've tried to share some of my own practical insights as we've worked through. For you now, what you need to be thinking about is what are the big areas? So just to quickly reiterate, 0 hours, the change in the qualifying period for dismissals, redundancy processes, mothers returning to work. Um, you will now want to go and look at your policies. A, make sure they are up to date, and B, start to think maybe about how you need to adapt to meet the new legislation that's coming. I mean, obviously, with that, in the absence of the detail, no one can do that extensively, but really be as ready as you can, I think, is my practical advice. Because we may be in a place where we need to start rewriting policies. Certainly, the team and I are waiting in anticipation, so we can advise you more on that. Um, and the short service dismissal, which I've just referred to, is going to be highly likely that's just not going to be allowed anymore. And so you need to look at your probation process and policies and make sure that your managers are really focused on that period of time being the time where we either confirm that we've hired the right people, which is hopefully the case, but if we haven't, we need to be quick on dealing with that. And we do take calls each week where probation periods have finished a month or two ago, and suddenly the manager thinks, do you know what, I'm not all that happy, I'm going to terminate. And that is just not an option. So really get your managers focused on managing performance in that, in that first 3 to 6 months. So start thinking ahead. If you're planning any particular reorganizations, just think about where there might be crossover with some of the upcoming legislation that we've talked about. Start talking to your management teams about the change because, very practically speaking, line managers will need to be clear about this stuff because it's going to have to impact the way that they manage staff. And within that, make sure that they are equipped with the understandings of the updated legislation. We do ourselves, as the HR department, provide training in these things. And I will, as I said, commit to continuing to keep you up to date and helping you where we can. Really and truly, and I sort of touched on this with the dismissal example, that you really, our advice mainly is to stay ahead. It's right that organizations are legally compliant, but that shouldn't be seen as the maximum way you operate. That should be seen as the minimum way that you operate. And if you're following employment law in the right way, you've got good processes, good policies, good employee relations, then you can move into a position where actually you leave that behind you. And what you're starting to do is operate beyond that, getting into performance management, and ultimately, sort of catapulting off from there. But if the basics are not in place, as I'm sure you all know, then it's going to be a tricky time for you over the next 6 to 12 months. Okay. I am conscious of time. I'm conscious also it's the end of the day, so I didn't want to overly labour, excuse the pun, the changes. I'm open now to any questions you've got or any comments you might have, anything you want me to go back and try and talk a bit more about. Please feel free to put those into the chat section of this Zoom call. Also, even just in general commentary of what you've heard, I'm always interested to hear people's reactions to what's happening. I can't see your faces. I'm wondering if there's looks of horror around what you've just heard. Thanks, Katie. So in the probation period, will we still be able to dismiss providing the performance is not up to standard? I think it's fair to assume that, Katie. Yeah. I think what we hope is that there will be some good guidance from ACAS, for example, around how we manage that process. And they do anyway provide some good guidance. But yeah, it will likely be performance based. So Olivia, with the protective rights for new mothers coming back, this still won't include cases of redundancies. So the legislation for dismissal due to redundancy is still in place. This is going to almost go further to protect mothers from being dismissed. So redundancy is one of the 5 reasons for a fair dismissal. What we are seeing is a suggestion that it will be actually any dismissal rather than just redundancies. But it will be interesting, Olivia, to see how the recent update overlays with this new level of protection, because even the timescales of the two are slightly out. Any general thoughts? Any general again, feel free. I'm not going to send them back to Downing Street if you tell me you think it's all horrible and you're moving to the Caribbean. Martina, so what if a mother wants to go back to work but part-time instead of full-time? Will employers need to provide that flexibility even if it doesn't work for the role? Great question, Martina. It certainly has to be considered, but there will always be criteria to apply as to whether that is reasonable for the business to accommodate. But generally speaking, particularly, to be honest, lifting it off the page a bit with returning mothers, it is usual to try and accommodate for very obvious reasons, their new working pattern. So if they're full-time but want to go part-time, one of the things to think about is, could I employ 2 part-timers to do one full-timer's job, or could the job that they're doing be reduced so that other people can help? So, and you're not suggesting this, Martina, but certainly the guidance we give with flexible working is don't just outrightly dismiss things. Do take time to think about how you might be able to approach something in a different way. So Valentina, we will be forced to accept part-time for mothers coming back to work, even if we need the work. I don't know that it's going to be quite like that, Valentina. Again, I'm not going to pretend to speak for the government, but it's going to be the case that mothers are going to be protected because of obviously having just had a child. And you will be expected to try and accommodate them flexibly if you can. Again, the parameters around that legally is to be determined, but we would always say, as I've just mentioned, that if you can work with an employee to support flexible working, particularly in the market today where it's so hard to find good people, which again, I'm sure you're maybe finding yourself, is if you can find a solution, which might not quite be how you would see it working, but if you can, then it tends to work out for the best for all involved. Thanks, Martina. Thanks, Valentina. Okay, great. So we are here to help, and hopefully this is an example of that. As the HR department, we do provide a fully outsourced HR support service, everything from a monthly retained service to pay-as-you-go work. This is a particular area of expertise for us, so we spend a lot of time updating our clients' paperwork, making sure contracts and handbooks are compliant. And beyond all of that, providing training, which we deliver in-house, looking at recruitment, redundancy support, and everything in between. So you have our details. We'll resend my contact details, but please feel free to reach out. We've also delivered, we haven't delivered. We've put onto our website some really useful tools for you to assess independently how near or far you are from from being compliant with the Employment Rights Bill. I really suggest you use this. It's free. I played around with it this morning, I'm going to be honest. And actually what I got back was really good. I've obviously got some work to do in my business, but that aside, it was really helpful. And there's also a white paper on there around the impact. So it's all free. Feel free to go onto our website, please, and download it. And beyond all of that, as I said, we are here to help you. So connect with us on LinkedIn, connect with us via Facebook, email me, call me, or any one of my colleagues. We are all here to help. So I think hopefully I've given you some time back on this Thursday afternoon. Feel free to stick around if you've got questions. Otherwise, thank you again for attending. I hope this has been very useful for you, and I look forward to interacting with you again soon.